I know that everybody's probably got some Netflix binge watching to do while we're all on coronavirus quarantine. Coming to you actually from my home office. I'm Kraig Strom. You'll actually see my slide pop up here in just a minute. Thank you all for joining us on the webinar tonight. Again, we've got a lot of folks, so I'm going to show you the Q&A button. Those of you who joined us just a moment ago, if you can't hear me, I know that my audio is active. I think that Amy's got it tested, but you can send in anything on the chat window, that Q&A actually. Use the Q&A. And the introduction that I want to cover is, first of all, what the heck is behind me, right? I am looking for a happy place, if you will, in this self-isolation. So this is the camp road that I used to spend my summers on when I was a kid. So that is actually Monmouth, Maine in the summer. So that's my backdrop. You can kind of imagine whatever your backdrop might be, and we'll get going on this. Now, the law firm that I work with is Barth Calderon. You'll see that name come up as I switch over on the screen, and we will be sure to email you all of our information and make sure that we're able to get in touch. I'd love it if you actually take notes tonight on anything that might be important to you. There's an important thing to remember as we get started. I am, in addition to being a paralegal on the law firm side of our house, I'm also a certified financial planner on the financial advisory side of our house, okay? So that means that although we're not going to talk about financial stuff for the most part tonight, if you have certain questions that are on your mind that are just, oh, you really need someone to go through these kind of things with you, you might consider that during our assessment, because everybody on the call has access to a complimentary assessment with me and my team. Make sure that if you have questions related to financial matters, feel free, jot them down, make sure that we cover that. That is just a nice perk of our operation, is that we have both sides that we can actually address. Tonight, we're really going to focus in on the estate planning, this coronavirus stress that we're all feeling with things like powers of attorney and such. So I'm actually going to switch over, share my screen, and we're going to start digging right in. Okay, so here we go. All right, let's share this screen. I want to make sure that I've got screen number 3. Amy, is that working? All right, sounds good. So as I mentioned, the law firm is Barth Calderon. Here we go. Right there. Make sure I've got my pen working. I love to actually write with the pen on the Barth Calderon there. Make sure that you know that's the name of the actual law firm. And my contact information is listed down below. And the best contact information to write down, if you want to write anything down, is Kraig with a K at barthattorneys.com. Kraig with a K at barthattorneys.com. Of course, I'll get in touch with you via email. I'll follow up with everyone so that we've got my info. So let's jump right in. First, a little bit of housekeeping on the agenda tonight. We are going to cover the idea of, just what is estate planning in general, the need for estate planning, the benefits and the scope of getting your plan done. We'll cover what is probate. And I have a bit of a take on it that I learned 20 years ago that has just stuck with me to help me understand what in the world is this probate thing, okay? And we'll talk about some planning tips along the way. So this is, again, there's going to be some things in here that you might hear for your situation. You want to make a note of those things so that we can cover that during your assessment. If you want to have that complimentary assessment, it'd be a good idea to take some notes along the way. Now, we are going to spend a good deal of time on powers of attorney. In this age of coronavirus, we have woken up, if you will, about the need for powers of attorney and how critically important they are, especially in situations like this today. And in our world, the legal side and the financial world, they've been important forever. It's just nowadays, it's really top of mind because of everything that's going on. So we'll cover that in detail. We'll also get into this idea of what to do in respect to the business and the impact of some of these conversations have if you own a business, if you own rental property, if you have those types of operations, those types of business assets. We've got to make sure that those are considered when you're talking about estate planning. All right. Now, a quick reminder, if you have questions, please use the Q&A at the bottom of your Zoom window. There is a Q&A button where you can actually ask questions, and we, Amy and I, have that screen up where we can see that you have got a question. Amy can get my attention if I'm missing it, and we can get your question asked. Now, I am going to take questions at the end also, so please take notes. And if we miss anything, because again, we have a lot of people on the webinar tonight, if we miss any questions, that's where your complimentary assessment comes in for us to talk about your specifics, all right? So let's start with this idea of what is an estate. Now, I'm gonna get this sucker to go. There we go. What is an estate? An estate is literally everything you own. It is everything you own. I actually heard someone, it was a retired IRS auditor, somebody who audits estates for taxes and so on and so forth. And the answer that they gave when I asked, so what do you consider to be the estate? Well, they said everything. And I said, what do you mean by everything? They said, we'll count the garden hose in the backyard. We'll count the garden hose in the backyard. So when we say an estate, we really do mean everything. We mean your house. Also, if you have a rental property, if you have a vacation home, right? That's going to be counted as part of the estate. If you have stocks and bonds, cars, yes, even the basic Toyota, all the way up to the collectible cars, those are counted in your estate. Now, IRAs and life insurance, that's a big question. Depending on how they're owned and how they're titled, IRAs and life insurance can definitely be included in your estate, especially life insurance when it's not handled properly. In certain estates, life insurance can seriously impact, in some ways negatively, the overall estate. So we'll cover that also. Now, the idea of estate planning. So we talk about the estate. So what exactly is estate planning? Estate planning is this, number one, the idea of asset management during your lifetime, making sure that your assets are arranged during your lifetime properly and managed during your lifetime so that if you pass, when you pass, that they can be managed properly after you're gone. The idea is they have to be arranged correctly during your lifetime, or they cannot be managed efficiently when you're gone. Now, you're going to hear this piece in our conversation tonight a number of times. This term, asset protection. So if you're out there in the world asking questions about living trusts and wills and powers of attorney and probate and such, and you're not hearing someone talk about asset protection in the overall conversation, I would submit to you that you're missing some very important details. Asset protection, protecting from creditors, predators, liens, and judgments. Creditors, predators, liens, and judgments. And I've heard some say floozies and gigolos, right? The idea that we just want to make sure that you're not missing protection items that you could have in your planning that would make sure that people can't come and take your stuff. That's the idea. We've got to make sure that we have proper planning in place, right? Now, okay, so now let's continue. Planning for disability and incapacity is another big one. we're going to cover this into some detail also. Planning for disability and incapacity. That is a critical conversation. Again, in this world of coronavirus, so many folks are waking up and realizing, wow, it may not be, you know, that terrible idea of death that's going to wreck my estate or hurt my family. It might be a situation where I am out of commission. I can't actually function on my own, right? We'll cover that in some specific detail also. Now, estate planning is also at its core making sure that we provide for family, spouses left behind, children left behind, even parents, grandchildren, making sure that those left behind have been considered in our planning. That's good estate planning. This item often gets missed. I will touch on this again in the presentation, but business succession planning. If you own a business, if you have rental properties, if you have a business partner, the need for estate planning is even more critical when you think of keeping that business moving forward in the terrible event that someone's incapacitated or died. That's a critical item that is often missed in business planning. They're not looking at the personal estate planning. So a very important item to make sure that estate planning also includes or is integrated with business planning. All right. Now, we will touch on this. This is a conversation we could have a whole webinar on just charitable planning. I've worked with folks for so many years that love the opportunity to give to charity, and I love building that into their estate plan. But that is a critical component that can go very deep and very wide as a conversation goes, and we'll touch on some of the key items to consider when it comes to charitable gifting. And then finally, the idea that we want to maximize the wealth transfer to the people that you care about, to the causes and the family members that you care about, and block every creditor, predator, lien, or judgment that you can. That's the idea, that if we build it right, making sure that no one that you haven't chosen can actually get in line to come and get your stuff. And that's the asset protection item that I mentioned earlier. Got to have asset protection in the conversation, or I really think you're missing a key component of the plan. Now, a couple of quick questions to set the stage, right? So what is the likelihood that you will get older? And of course, it's 100%. Now, unless you're my mom, is my mom on the webinar tonight? I can't remember. So I don't think mom's on the webinar tonight. So my mom at 65 said that she would no longer get any older. At least she wouldn't tell anybody. But, you know, she continued to get older. She just stopped telling anybody that she actually, you know, got older. Okay. So the idea is that we're all 100% guaranteed we're going up in age. That's the only direction. And then, of course, that leads to the next one, which is a 100% chance all of us will not leave here except in one direction, right? We all have mortality that to deal with in one way or another in our own way. But the big one that is getting a lot of folks riled up, and again, our phones and our email have been going crazy on this one, is what is the likelihood that you'll actually be incapacitated? That's a big one, right? Because nobody really wakes up in the morning thinking, man, I wonder what happens if I get incapacitated today. That's not a topic that we generally think about until today. We're all now a little on edge with, geez, what happens if, right? What happens if I'm on a ventilator and I can't actually make my own decisions? That's a key item. We'll cover that as well tonight. Now, I love this slide that's coming up because all of these things, right, come down to this idea of planning, proper estate planning. And what happens if you haven't done any of it, or if you haven't had it updated? What happens if you have nothing in place? That's okay, because we're the government. We're here to help, right? That's what the county court system will say to your family. They'll say, don't worry, we've got you covered. right? We're here to help. And what that is if you die without any estate plan in place, don't worry about it, because the county courts have your estate plan in the drawer. It's already pre-written. It's very nice. It's been written for many years, actually, and it's just for you. It's called an intestate will. It's an intestate will. When you die with no plan, you are intestate with no plan, okay? So here's some key items that come along with an intestate situation. So you'll get a probate judge that will appoint anyone they want to manage your assets. They will appoint anyone they want to manage your assets and distribute your assets. They will basically cash in all of your assets, whether it's a house, stocks, rental properties, businesses, whatever it might be. Here's a great one, very unfortunate situation. One of my clients really encouraged his older brother, please, please, please get your estate plan done. I had helped the brother with his estate plan, and his younger brother now is going to the older brother saying, please get your estate plan done. And he didn't get it done, and sadly passed away kind of suddenly of a heart attack at 74 years old, and left behind multiple houses and classic cars at a time when classic cars were not fetching top dollar, and he had no plans in place. So guess what? They all get to be liquidated at whatever the market will bear at that moment. Stocks, real estate, whatever it is. An intestate situation means that the probate court doesn't care. They just say, sell it all, we're done. And that's exactly what happens. They liquidate everything. What if you have kids? Well, you might not want your kids at 18, 19, 20 years old to receive $200,000, $300,000, $400,000 of value from the sale of your home. Well, if you die intestate, doesn't matter. The courts will distribute whatever percentage your kids have coming to them. They just give them the money. Whether or not the kids are capable of dealing with it or not, they will get the money. And unfortunately, we all know what might happen with that, right? So the idea there is that an intestate situation, we can keep going down the list, but it just keeps getting worse. Intestate means that someone who doesn't care about you or your family or all that you've built gets to decide what happens with all that you've built and with the people you care about. So intestate, definitely not something that anybody would want to look forward to. Now, this next one though, it's really important. This is the one I mentioned earlier. It's this question about what really is probate. What is probate? Well, we can thank our old English founders, for bringing the probate system from merry old England. And essentially it has evolved and grown into the bureaucracy of the probate system here in the United States. And I'm here in California. We have one heck of a probate system, as does most states, as do most states. Now, this is the way the probate system was explained to me probably 20 years ago. Probate deals with the assets of deceased people. A probate asset is the asset of a deceased person, someone who died intestate. Someone who has a will might also go to probate. They will go to probate. But the probate process is dealing with the assets of deceased people. That is an important item, that when you think about a probate asset, it is the asset of a deceased person. So that's what goes through probate. So as we get into this conversation about living trusts, you'll then start to understand how we avoid probate. Now, probate comes with, as you might imagine, a built-in cost. So probate has a serious cost depending on your state, but here in California, the probate cost is not just money, it's also time. Probate costs in time is tremendous. What I want you to pay attention to on this list here, just to make sure that you can see it, is this idea that it is a graduated scale that goes up depending on the size of your estate. So depending on the size of your estate, now what this doesn't include is the increased costs and fees associated with the attorneys. These are just statutory, mandatory minimum fees. These are the minimums. That's not what the attorneys will ultimately charge. This is what they can charge. This is their minimum, all right? And it's very important to note that it's not just money. The average probate in California, now this was before coronavirus. Before coronavirus, the average probate was 18 to 24 months. And now I've heard people say that they're expecting 36 months for probate because of the backlog that's happened due to coronavirus. And probate happens when we are taking care of the assets of a deceased person that didn't have a plan in place. They had no estate plan, all right? Now, there's another piece with probate that is critically important to look for. It's this idea of privacy. So Amy, my wife, actually showed me an article today that there's this huge increase in people getting online wills and powers of attorney and things, and they're going to these cheap online services to get this kind of stuff done. Well, a lot of folks go out and they get their will done cheap online. I'll tell you a story about one of those here in just a minute, but they get it done and they think, oh, I'm all set, I'm all good. Well, remember, a will is simply instructions for the probate court. It's just instructions for probate. So your family is still going to probate, and then they get to show all the dirty laundry of the family estate because probate is not private. Probate has no privacy whatsoever, completely public record. Your estate, all the assets that you owned, all of the bank accounts you had, all the property, all of that is wide open, and it's wide open for even nefarious people to be noting, hey, I wonder what the kids are going to inherit. They can see it all because it's public record. So probate is extremely public, and when you shortcut things with a DIY will, you might end up, number one, having no privacy, no asset protection conversation. Kids will still end up in probate, and things like this will happen. So what in the world is ancillary probate? This is a big one as well. You're going to hear me say that all the way through this because there's so many of these pitfalls of proper estate planning that if it's done right, we avoid them all. But when there's not done right, the pitfalls are enormous. They really are. So this is a true story. Unfortunately, someone, this nice lady, she's a daughter. Her mom and dad have now passed away, and she calls me after her CPA had made an introduction and said, well, mom and dad passed away, and mom and dad had a home here in California, Orange County, California, and dad had a home in Ohio. He has this old home in Ohio. So here's the thing, the home in Ohio is worth $90,000, and the home in California, because if you're not familiar with Southern California, a basic home in California is $700,000 in Orange County, California. Basic house, 4-bedroom, 2-bath kind of house. So between those two properties, there's basically $800,000 in assets, right? So if we go back just quickly and we look at that list and we think, well, $800,000, it's going to cost what? $19,000 in probate fees? That is incorrect, because mom and dad had a home in California and there's a property in Ohio. And guess what mom and dad did? Mom and dad did a DIY will and a trust online, and they never finished it. They didn't finish it. They didn't put the properties in the trust correctly. They never got the trust done because they're not lawyers. They didn't know what to do. They thought they just signed the document and they were done. They thought it was over. And unfortunately, their daughter found out that the properties were still listed in mom and dad's name. They were not put in the trust correctly. So that $20,000 probate that we just talked about in California, she actually has to open up a probate in Ohio and a probate in California. It's called an ancillary probate. She has to open 2 probates. It'll probably cost somewhere around $30,000 when she's all said and done to take care of the 2 properties. And one of them's worth $90,000 in Ohio. It's really unfortunate because mom and dad did a DIY will and trust, and they didn't know how to finish the trust properly, okay? And that goes to this point here. Folks, I hear it all the time. All the time I hear this, I don't need to worry about probate. I have a will. That's incorrect. Remember, a will is simply a list of instructions for the probate court. It goes directly to probate. A will by itself is a ticket to probate, okay? Now, there's another one I hear all the time. Doesn't joint tenancy avoid probate? Well, yes, it does. In some states, there can be issues with probate for sure, but let's just talk about California because that's where I'm at, and your situation might be different, but here's the key that I want you to think about. Joint tenancy is this situation where a husband and a wife own a piece of real estate, for example, and they own that piece of real estate together, joint tenancies. So if husband dies, the wife simply keeps the property. There's no issues whatsoever. If husband dies, the wife keeps the property, no problem whatsoever. But here's an actual big risk. If I just put my kid's name on the property, what if I just put my kids on the property? I don't need to have a trust, right? That is true. You can just simply put the kids on your home or on your bank account, and you don't need a trust. There's 2 things that happen there. One is a tax problem. Just to give you an example, let's say that mom and dad paid $30,000 for their home in 1959. True story. And then they give, because husband passed away, so now mom, she gives half the house to her daughter. Well, guess what her daughter's tax base is? Her daughter gets to keep the 1959 tax base. So someday, 30 years later, when the daughter wants to sell the house, guess what her tax bill will look like? It will be ginormous. It will grow. It'll be taxes paid from 1959 to whenever she sells it in the future. Because when you put your kids in joint tenancy on your home, you give them your tax base just from the day you start it. That is a huge problem. The other piece is when you put your kids on your bank accounts, you also bring in the kids' risk. True story again. Mom put son on the checking account because she thought it would make it easy. Don't need to get a living trust. We'll put the accounts with his name on it and such. Nice and easy. The son made an honest mistake and paid his taxes wrong. He actually made a mistake. He underpaid his taxes by $15,000 one year. Well, the aftermath of that is that he moved 3 times with his job. 3 times. And the IRS sent his tax notice to his old address. They sent the tax notice to the old address, so he had no idea. He'd never received a tax notice from the IRS. Well, that's okay. The IRS didn't worry about it. What they did was they drafted all the money and penalties out of mom's checking account because he was on the checking account. So they didn't worry about it. They just drafted the money that he owed out of an account that his name was on. And mom found out, by the way, at the grocery store when her ATM card wouldn't work. Now, it got straightened out, but wow, the risk of the kids comes along with the joint tenancy. So having an estate plan in place actually takes care of that. We don't worry about any of that. Now, the next item is to cover this just briefly is will substitutes. This idea that you can have certain things that pass right by probate. They do not go through probate. Things like IRAs, You've got an IRA over here. You could also have a SEP IRA. You can also have a 403B. You've got a variety of things, 401k. That doesn't go through probate. But you can have a problem when your life insurance policy or your IRA has a beneficiary designation that is incorrect. I've seen this countless times where beneficiary designations were not changed when someone got a divorce or one of their kids actually got into some trouble with the cops. I have one right now where the beneficiaries weren't changed when mom passed away. Her son, who's in prison for drug problems, is now the beneficiary of her retirement account. Now, she might have still wanted son to receive that, but maybe not while he was in jail, right? So it's important to always update beneficiaries, okay? Now, please keep in mind, if you have any questions, jump in there with a question on the down below. You've got that item that you can actually put in the Q&A section. We are watching that. So I'm going to get into this next section here. It gets serious for me. Every time I see this picture, it definitely really sets this stuff and brings it home for me. This conversation is critically important. It's this idea of planning for incapacities. And some of you on the webinar tonight might recognize the photograph here of Terri Schiavo. Terri Schiavo, became the poster person for proper planning when it comes to incapacity during lifetime. She became, in 1990, from 1990 when it all happened, she became the name associated with get your planning done and do it now. And for those of you not familiar with her case, Terri Schiavo was 26 years old when she collapsed on her kitchen floor. She'd had cardiac arrest. At 26, she had cardiac arrest. And unfortunately, they did not find her until she had actually suffered a significant amount of oxygen deprivation to her brain. And doctors tried and tried and tried for weeks and weeks and months and could not get any response. And they had diagnosed her as brain dead, that she was in a vegetative state, permanently unrecoverable. And it should have been a simple choice for a husband to do what he felt best for his wife, in my opinion. Unfortunately, what it became was a 15-year, remember that, it was 1990 to 2005 before ultimately her husband was allowed to actually let her go, because her husband did not have any powers of attorney, did not have any incapacity paperwork, and Terri Schiavo's parents fought tooth and nail, back and forth, back and forth. It was just heart-wrenching to see the history of that all unfold. And every time I think of it, I'm just glad that my wife and I have these things taken care of, that we have this stuff so we don't have to worry about that. But that's the idea of planning for incapacity and why we really need to take it seriously. So let's talk about it. Let's talk about this idea of powers of attorney and what they mean. So I have countless times sat down with clients and people that I've met through personal relationships, business relationships, partners, attorneys, and CPAs. And when I ask them about estate planning, or they ask me, I ask them, what are they thinking? What is on their mind when it comes to estate planning? And they say, I want to make sure I avoid probate. I don't want my family to have to pay those dang probate fees. And I want to make sure that my family gets all my stuff and it goes to the people that I decide. And I said, that's great. That's excellent. You know what we don't hear is, we don't hear any conversation most of the time about, well, what happens if I'm unconscious? What happens if I'm in a car accident and I can't actually make any personal decisions for myself? What happens if I have a long-term illness or a coma, right? That I'm completely out of commission, and how will my family take care of me, right? So think about this. that a will and a trust is really, we're taking care of the survivors. We're taking care of those people left behind. Whereas a power of attorney is all about you. It's all about taking care of you while you're still alive, making sure that your life continues on in the way that you prescribed, the way that you laid it out. That's the critical piece with powers of attorney. So there's two different types of powers of attorney primarily that we'll talk about tonight. And one, as we look up at the top, is this durable power of attorney up here at the top. And this is for financial matters and property. Durable power of attorney for financial matters and property. That is items like what to do with your real estate, how to deal with your IRAs, checking accounts, anything related to your medical insurances, your life insurance, your homeowners and car insurance, any work-related plans related to pensions and benefits. Those are financial matters. Those are things that your durable power of attorney for property and finance covers those specific situations. Now, a key one that's happening today that a lot of folks miss is this idea that they don't have powers of attorney for their elderly parents. Powers of attorney for their parents. So let's talk about that. This idea right here at the top, power of attorney for my parents. Let's talk about my mom. My mom is currently hunkered down in quarantine because she is in the demographic at most risk when it comes to coronavirus. So she's really doing her best to stay isolated, her and her little dogs, and she's just hunkered down in her home, and my sister lives really close by her, so they're just helping her out with grocery runs and things like that. My mom is completely capable of functioning on her own. She can pay her bills. She can do all the various things that she might need to do. But does she want to do those things right now because she could put herself at risk? So we actually have a power of attorney for financial matters and for property that says if something is needed, I could step in and actually act on her behalf. I could step in and sign when it comes to anything related to real estate, anything related to her Social Security benefits, anything related to financial matters, property matters. I could actually step in and help her so that she doesn't have to go to the bank, for example, right? I could actually go do that for her because we have her power of attorney for financial matters. That's a critical item that most people are thinking about, well, I've got to be unconscious, and then my power of attorney kicks in. Well, coronavirus has really reminded us that it's very possible to be in a situation where you just have to self-isolate. You have to kind of quarantine yourself and wall yourself off from the world. And that means you might need a power of attorney to step in with someone acting on your behalf, right? Now, adult children. Let's talk about that for sure. You might have adult children out there that maybe they're married, they've got kids. This could affect them in a very similar way, where it's important that our family has those powers of attorney in place as well, so that we can all step in and act on their behalf when necessary. We just don't know when that might be. It's just important to have the power of attorney there ready to go. This right here, this one here, the business impact on a business. This is a great example that's happening right now in our firm. Our founding partner, Harry Barth Calderon, our founding partner, he is also in that demographic that is most at risk with COVID-19. So to be safe, he and his dear wife are hunkered down, right? He's still running a law practice from home, but what if he needs to act on the law practice as far as the general partner? Well, that's where he has a limited power of attorney that actually gives his son, who is the general partner with him, the managing partner, gives him the ability to step in and take care of business matters so that the business can continue, so that Harry doesn't have to come out of quarantine to sign things or act on behalf of the business. He's got an agent, his son, an agent that can act on his behalf. So the power of attorney for financial matters is critical. I've actually seen so many times over the years where folks say, yeah, I'm calling in regards to my husband's 401k. Okay, what can I do for you? Well, we need to make a withdrawal. Okay, well, just go ahead and let me talk to your husband. Oh, he's not available. He's actually, he's currently unavailable. Well, I need to talk to your husband. Well, I should be able to request a withdrawal. No, you can't. You can't request a withdrawal from your husband's 401k because you don't actually have power of attorney over that account. So even simple things like that might be difficult in a situation where someone is isolated or fully incapacitated. Now, this one here, the Advanced Healthcare Directive, this is kind of the scary one that, I mean, a lot of folks have a hard time when I get into this conversation about power of attorneys and the healthcare directives. Now, this is called an Advanced Healthcare Directive, also called a Durable Power of Attorney for Healthcare. Now, in California, we have something called the Natural Death Act. Basically, it's people's right to die. You have the ability to choose, if you want to choose a course of action that will ultimately lead to the end of your life. Now, what if you lose the ability to say that, to actually tell someone that? If you have not written down in clear and concise, provable fact that this is what you want done, in this age of lawsuits, medical practitioners, hospitals, doctors, lawyers often go, whoa, I don't know. They step back because they don't want to risk themselves by unplugging someone and not knowing whether or not they have clear permission to do so. So if you haven't actually written it down, that Natural Death Act, your right to die provision, may not actually be implemented if you're not physically able to say, this is what I want. You've got to actually write it down. You've got to put it in a legal form that a medical doctor, a hospital can say, yes, we have this, we're okay, we'll do that, right? That's a key item. Final wishes. If there are specific final wishes that you have, perhaps religious beliefs, very specific situations that you want to have certain things done with your body, whether it's anatomical gifts. Some folks have very strict no-go on that area. Others, for example, think, oh, I've got an organ donor sticker on my driver's license, that covers it. Yes and no. Oftentimes that doesn't work, right? What does that mean? What does the sticker on your license actually mean? Do you want to give your body to anything? Research cadaver at a laboratory? Do you want to just give certain gifts to people who are going to benefit while they're alive? What exactly do you want to have happen there? And what we're trying to do in this case is make sure that your family, the people that are there trying to make decisions for you in this terrible situation, that they're not actually struggling through the decision, that you've written it down. You've said, this is what I want. This is what I don't want. This is specifically the limits. This is what I want done. This is what I don't want done. That's a critical item. Long-term care, whether you need a nursing home, that's a big one, right? So there's this argument with some folks, again, coming back to the Natural Death Act that says, just let me be, right? And then this idea of, well, long-term care, we can keep you, we can keep you in a nursing home for a long time. Well, maybe you want that. Maybe you don't. You've got to write it down. You've got to make sure that that's specified very clearly. Now, some folks are out there thinking, well, I have a power of attorney for financial matters, and I did one 10 years ago. I'm here to tell you, just as a recommendation that I've heard from attorneys for 20 years, it's a really good idea every 3 to 5 years minimum to just get new ones, brand new ones, freshen them up, because financial institutions and hospitals, they don't really like old, stale powers of attorney. That's the way they look at them, because everybody's worried about being sued. So hospitals and financial institutions will look at an old power of attorney and think, you got anything newer? They'd like to see a new one. You want to make sure that your family, your representatives have good, fresh documents that just make their life easier. Okay? Just important there. Now, I want to finish on this note, on this topic of powers of attorney, again, really to drive home this idea of our adult children. Our adult children, and by the way, that is my daughter Madeline and I in up in the mountains in the woods on a walk with her boyfriend and their dog, and we're just out there having a good time up in Flagstaff, and it was a great day. Now, fast forward to this year, and we're looking at Northern Arizona University, where she goes to school, being shut down for coronavirus. Am I worried about my daughter getting coronavirus? No, not really. Am I worried about something maybe happening to her as a result of all of the calamities going on around her where she might be in trouble? Yes, that causes me concern. So I made sure, and my wife and I made sure, we have a power of attorney set up for Madeline. So if she's ever incapacitated, we can get in there and help her to take care of things. Because I want you to hear this. This is very important. People think, well, if my daughter was in a car accident and she's unconscious, well, I'm her mom or I'm her dad. I'll just go there and they'll let me take care of things. No, they won't. They will not. She's an adult, and if you don't have a power of attorney that says that you have the rights to act on her behalf, you don't. You get to get a lawyer and you can make that fight in court. So it's important to have those powers of attorney for your adult children as well, if they don't have someone that they can have step in for them. Like Madeline doesn't really have someone that we would step in for her. So we are those volunteers in case something happens. So that's a good item. It's never going to happen. That's what we tell ourselves, right? It's never going to happen to my kid, but you always want to make sure just in case. I mean, the worst thing that I think could happen in that case is it happens and then we struggle through the fact that we didn't have the legal stuff done. So I'm really glad that we've got it done. And let's make sure that if that's an issue for you, we put it on your list of things to talk about during your assessment. All right, now, got a question?
Question in regards to that, even if the child is living at home at say 18 or 19?
Oh yeah, great question. Even if your child is living at home at 18 or 19 years old, oh yeah, you better have a power of attorney. So I'll give you the example. When my dad got sick with cancer, my dad, he's 58 years old at the time. He got a sore back, a really sore back. And by the way, my dad had quit smoking years ago and he was happy to be early retirement, and he got a sore back. And eventually the pain was so bad that he went to see his doctor, an orthopedic surgeon. He said, "Oh, I must have sprained my back." Well, as it turns out, no, you have cancer in your spine from your liver, from your pancreas. Go see your kids, go see your family. Because my dad got diagnosed with pancreatic cancer, and they found it in August and he was gone in November. It was very quick. We got him back to California, and my mom and dad went into the Cancer Treatment Center at Loma Linda University, world-renowned cancer center. My mom is on one side, my dad up at the counter, and they said, "Hi." One of the very first things that they asked for was, do you have your power of attorney for financial matters and for healthcare? Financial matters and healthcare. My mom said, "I'm his wife. I'm right here." "Yes, ma'am. Do you have your power of attorney though for financial matters and for healthcare?" And she said, "Well, no, I'm his wife." And they said, "We need that." Well, thankfully I was able to email that. I had already done that for my mom and dad, and I was able to email that directly to the hospital. So they had that on file very quickly. Financial matters, so that my mom is able to deal with the insurances for my dad, and medical, so my mom is able to deal with my dad's medical stuff if he was not able to speak for himself. So the answer to the question, your 18 and 19-year-old kids, yeah, you need powers of attorney for your 18 and 19-year-old kids. That's just a reality nowadays. You absolutely do. That's a great question. Thank you. Now, how about the minors? Let's talk about them kids, right? Let's talk about the little ones under 18, right? Yeah, they're not so little when they're 17, 17 and a half. And at under 18 and the minors, this is a big, big, big one that folks get, all the time. I actually just had this one happen today. I asked a friend of mine, I asked her, if something happened to you and your husband, who would be the guardians of your children? She has 3 children. Who would be the guardians of your children? And she said, well, I suppose my parents would be. My parents are young enough and they live close by, so it would be my parents. And I said, but you don't have a will and a trust and an estate plan or anything, right? No, we got to get that done someday. And I said, well, do you realize that the guardian of your children is already set for you? You don't actually have a choice unless you make the choice. It's already made for you. And she said, what do you mean? And I said, well, if you and your husband died, the county of Riverside, California would become the guardians of your children. They would have legal custody of your children, and your family can hire lawyers to go argue on who gets custody of the kids. But it's default that the county child services, family courts, would actually be the guardians of your children unless you have it written down. Remember, the key here is write it down. If you don't have it documented, written down, the government is here to help and they have it already written down for you, right? I'm not suggesting that the parents, grandma and grandpa, would not ultimately become the guardians. Not suggesting that at all. What I am saying is that it's not set in stone, right? What if there's strife in the family? People could argue about that kind of stuff, and they often do. It's important to get it done right. We also have to address things like social issues, right? Making sure that there might be social and economic differences with potential guardians, religious issues. Where's church? Are they still going to be going to church? In-law issues. Is there going to be fighting and infighting amongst stepsisters and brothers and so on and so forth? Geographic issues is a big one. Where the kids end up. And then often missed is economic issues. Do we have enough life insurance to make sure that the guardians that are set to take care of our children will be financially able to do so? That's really important. It often gets missed when we talk about guardianships. Then, what if our kids are very young and they have life insurance? That's great. But now, who manages those assets? Who manages the assets to make sure that they're distributed correctly for the kids? Right? Is it the same person as that are guardians? Sometimes that may be. But these are all decisions that can be made, right? This can be fixed with just a little planning. That's the idea. Now, the big one that has been out there in the conversation that we haven't gotten to yet is this idea of a living trust. So what in the world is a living trust? And I want to take you back just for a quick second. Remember what a probate asset is. A probate asset, assets that end up going through that terrible probate process, those are the assets of a deceased person, somebody who died with no trust, no plan, and those are the assets that go through probate. So if we do this, right, if we want to avoid probate and control our distributions, if we do this and we create a living trust and we take all of our stuff and we run it through a living trusts do not die. They don't die. So if probate is for the assets of a deceased person and we give all of our stuff through our trust and a trust doesn't die, no probate. That's really the nuance of how to avoid probate. Just make sure we don't have any assets of a deceased person because we flow everything properly through a living trust and we avoid probate. And if we do it right, down here, we avoid probate expenses, executor fees, we avoid unnecessary attorney fees, And even more so, if we do it right, we lower potential death taxes, accounting fees, appraiser fees, all of these things that can be significantly reduced or eliminated because we had a trust. We have a living trust. They have to work together as an entire estate plan. Now, let's cover this idea. What do we got? We might have a little freeze. Is everybody, if you can't see me, or if I've actually froze up a little bit, please chime in with a message. We'll, it looks like we're still going, but it looks like Amy just dropped off, and we'll see if we're still getting the, it looks like I'm still actually connected. So everybody out there, if you're missing me, please let me know. Yeah, we can see and hear you. Thank you very much for letting us know. Appreciate that. We're loving our technology. All right. Now, this is another one of these analogies that I was given. Again, I say this is my line 1,000 years ago when I started in this business, that when someone passes away, you know, especially when a husband and a wife are gone, grandma and grandpa, you know, have left, and now it's time to settle the estate. An ATM machine pops up in the living room. An ATM machine pops up in the living room, and a line forms at the ATM machine at grandma and grandpa's house. And that line is going to have the IRS, it's going to have lawyers, it's going to have 401k companies, investment companies, it's going to have mortgage people, it's going to have all these folks in line at the ATM machine looking to take out money from that estate. Now, proper estate planning is going to address this idea of those invaders to the estate. We've got to pay attention to the IRS, right? Whether it's estate taxes or, like we said before, this idea of taxes because we chose maybe the wrong way to gift a piece of property to our kids, right? We want to make sure to minimize taxes. Probate, we want to, that's a big invader. We're really just, that's the one we were talking about. But how about this one? Beneficiaries, creditors. What if one of our kids was in a lawsuit and has a judgment against them, and then all of a sudden they inherit this great big chunk of money from the sale of our home because we died suddenly? Well, now that piece of real estate is inherited in the wrong way, and perhaps their creditors can go ahead and get a hold of it. That's a big deal. We've got to make sure. What if one of our beneficiaries had gone through or is going through a divorce? Do we want an ex-spouse having a potential to be able to get a hold of those assets? We want to make sure that we keep those assets specifically for the beneficiaries we choose. Another one is that this is the one I see in my family. I actually saw this with my uncle, unfortunately. This overbearing spouse, right? There's this overbearing spouse. Do you really want that overbearing sister-in-law, brother-in-law, aunt, nephew, niece to be driving on top of that beneficiary saying, hey, you've got to give me that money, right? You've got to pay attention to who's receiving the money to make sure that potential invaders, they often come from within the family, right? Now, children with disabilities. I see this so many times that kids who might have a disability, they might have Down syndrome, they might have a spectrum type condition that is going to cause them to be cared for by family members, if not most of their life, all of their life. A situation where they will receive state assistance, government benefits and such, that if they then receive an inheritance, they will lose all of their state benefits, all of their disability benefits, all of those specific things that are very helpful for them might be lost if they inherit all of a sudden a big chunk of money. So it's critical in those kind of situations to have conversations about children's trusts, special needs trusts, making sure that if those kids inherit money from you, it is separated in such a way that it doesn't cause them to lose their benefits. So that is, again, something that can be done but only if you've got the right kind of estate planning in place, right? Now, I just had this one happen recently as well. Children with drug and alcohol or other addictions. This is a situation that unfortunately I've seen many times, that you can actually build into your estate plan provisions that say that my son or daughter will inherit money over a specific period of time or at a specific time for a certain reason, as long as they have a clean drug test. You can actually build in, these are morality clauses to make sure that they're clean, because one of the worst things that can happen to someone in that situation is all of a sudden they get a distribution of $250,000 and they're a raging drug addict, and now they've got $250,000. That could actually accelerate their path towards a really bad ending. So the idea that you can actually build in a provision that makes sure that they get help, but only in the amount that is needed for help, not just simply handing them gobs of money. Improper trustee arrangements is another item that we can cover in more detail, but the idea that you've got to make sure that you have the right people chosen to manage these things after you're gone, or while you're still alive, these things can kick in. Now, a big invader to the estate, this is actually one that a lot of folks miss. One of the biggest invaders of the estate when someone dies is the kids themselves, right? The average inheritance is gone, consumed in 1 year. 1 year, it's gone. You can build in to an estate plan spendthrift provisions. You can build in protections against bad financial decisions. You can actually protect against unscrupulous new spouses. And remember, floozies and gigolos and creditors and predators, we can build in protections to make sure that all the money and the assets that you work so hard for don't just get frittered away, right? That's an important piece. All right, now let's talk about this. Now everybody's still able to hear and see on the webinar. Okay, I think Amy's getting back online over there. I'm just going to double check the questions because we're coming towards the end here. We're going to be wrapping up in a little bit. We're going quick. Yep, perfect. All right, so please chime in with any additional questions you have and we'll keep on going. Now, the estate distribution options. This is a great conversation that when we actually get into working on your specific estate plan, for example, we really get into the nitty-gritty as far as how you would like to see your estate distributed to children, to charities, to grandkids, etc. And you can have a variety of methods, things like sprinkling trusts, where we're just going to sprinkle the money out over a certain period of time carefully. We're going to make sure that it lasts. You can have lifetime trusts for adult children to keep their money in trust so that creditors can't touch it. Special needs for children with disabilities, that is a very important conversation. You can actually, again, provisions for children with drug addictions. And you can also, this is one that we also do offer at our firm, the option to have a professional corporate trustee. We actually have this service at our firm where some folks might have dynamic family situations, and that's a nice way of me saying that people don't get along. And instead of putting someone in the difficult position of being the trustee, maybe in a very hard situation with everybody fighting, we can actually have a corporate trustee that is professional, that's maybe perhaps in our case a lawyer, that will actually take care of following the regulations, that is going to be a third party that can step back and just follow your wishes. And corporate trustees are not always super expensive like some people think. They can actually be very nominal and affordable in relation to the overall estate. Sometimes it can be a great way to go. We do offer that service. Now, charitable planning. This is one that we have this conversation with all of our clients. We always ask, do you have any charitable intent? So these are great times to have the conversation about, for example, Amy and I, you know, we're going to be updating our estate plan, and I would love to leave a certain amount as a benefit to, let's say, the Humane Society or a particular animal, you know, charity. We are very pro-animal friendly. There are a lot of folks who might want to leave money to a church or to a certain other charitable cause. This is the time during your estate planning to really write it down. Like we said, everything about writing it down is critical. And you can go through a number of different ways, but there's 7 strategies that I'll just tick off real quick. In your estate plan, you can actually give outright gifts. You can have bequests via an estate plan where the gift only happens when you are gone or when you and your husband are gone. Let's say you and your spouse are gone, okay? The gift of life insurance, that is a phenomenal way to actually give money to charity, because you can take a relatively small amount of money and give a huge amount when you're gone to a charity. We do that a lot. We see that happen quite a bit. You can actually gift IRAs, 401ks. You can create charitable trusts, charitable lead trust, wealth replacement trust. You can do all of these fancy things. You can do them all. The reality is that charitable planning can be incorporated into your estate plan, and we love that conversation. So if you have a charitable mindset, please make sure that we cover that in your assessment. Now, a few words about business succession planning. Now, business planning. Let's say we've got 2 business partners. We have 2 business partners here. And these ladies, they like each other. Everything's great. They're happy to work together. And this lady on this side over here has her estate plan 100% done. This lady over here doesn't have any estate planning at all. Now, they're equal partners in their business. They just have a standard business. They're very successful together. And unfortunately, the lady on the right doesn't make it home one day. If she passes away and she has no estate planning, guess what the lady on the left gets to deal with? She gets to deal with the probate nightmare that is going to ask to sell half of the shares of that business. Remember, no estate plan means that an intestate situation is now up, and the courts will say liquidate half that business because we need to settle this estate. And now the business partner on the left is stuck in a situation where they've got to figure out how to actually liquidate half the business to satisfy the probate from the partner who didn't have any estate planning done. So it's important that if you have a business, if you own a business, to have your estate planning coordinated with your buy-sell agreements, your corporate documents, your partners, and all of those things. It's really important that if you are a business owner, that we're discussing that in conjunction with your business planning. Now, we're going to finish up with these few slides. The ultimate need for estate planning. The need for estate planning, I hope you've gathered as we've gone through this, is, to say the least, critical. You've got to provide for incapacity. We've got to make sure that if you are unable to take care of your business, family or professional, you've got to have representatives written down. You've got to make sure you've got that written down that they can take care of things. You've got to have that taken care of. The estate planning will provide for surviving spouse and children, protecting the beneficiary's inheritance, providing for special needs children, maximizing these new portability laws in California and other states. There's all these new portability laws that allow you to transfer certain tax favored situations from one place to the other, and you've got to take advantage of that, but it really can only be done with the right kind of planning. Business operation and succession planning. This is a good one. Provide liquidity for debt and tax payments. That's where things like life insurance come in, and things like, again, avoiding probate, charitable considerations. And then my final thought on this slide is really, and you heard me share this story earlier, that this stuff is not just simply easy. Please whether it's with myself and my team here at Barth Calderon, please work with an attorney to get this stuff done. You've got to have an attorney on your side to be able to rely on that person putting their name and their firm and their effort behind it so that you know that it's getting done. You want to make sure that it's done right. This is stuff that really shouldn't be done on a DIY type of a basis. Now, all this to be said, vacation planning versus estate planning. Seriously, let's think about this. We're all kind of isolated. Nobody's going on vacation right now, but you think about the average vacation, 1 week of vacation versus a lifetime that you've worked hard for. And what I'm saying here is that the average estate plan, getting it done right, doesn't cost more than a week's vacation. Really, sometimes it's less depending on the type of vacation you might go on, right? It could actually be less. It's really important to get it done and keep it in perspective. And I'll leave you with this one thought. It's time to get off the log. And what I mean by that is this riddle. It goes best with this riddle. 4 frogs on a log, and 3 of them decide to jump. 4 frogs on the log, and 3 of them decide to jump. How many frogs are left? All 4 frogs are still sitting on the log because they only decided to jump. I'm asking you to get off the log. If you haven't done your estate plan, let's have a conversation about it. Let's get that started. Send me an email, Kraig@barthattorneys.com. Those who get in on my email first will get first in line. Kraig@barthattorneys.com. Get off the log. By the way, that is actually the ceramic frogs that are on my desk for years to remind me to help people get off the log and take action. That's going to wrap it up. If you've got more questions, we'll check. We've got a few questions coming in. So please, Amy, what do we got?
Is a power of attorney the same as a durable power of attorney?
Great question. Is a power of attorney the same as a durable power of attorney? Yes. These phrases you'll hear interchangeable. You hear durable power of attorney. You'll hear advanced healthcare directive. You'll hear durable power of attorney for healthcare. So yes, those things oftentimes are interchangeable. The documents themselves are not always the same, meaning that the firm, whoever helps you draft those documents, one firm might be far more comprehensive than another. Sometimes the very generic powers of attorney that you can get online for cheap are really not that great, and in many cases can be contested and questioned. So that's something to keep an eye on, okay? Got another one there?
Yep.
Go ahead.
Is an estate plan done in one state good in all 50 states?
Ah, yes. Actually, the reciprocity with estate plans is actually pretty much universal. That you can have an estate plan done in Florida and then you move, well, no, wait a minute. What's a good one? We had just recently folks who were in North Carolina that ultimately then moved to New Hampshire. And the question was, is our estate plan still good? Yes. If your estate plan is 3 to 5 years old, regardless of whether you move state to state to state, 3 to 5 years old, you really should have it updated. And you probably want to have it amended and corrected. Things are always moving in the probate and estate world, and you might have moved into a state that does have some provisions that actually need to be addressed. Now, we work with clients actually all over the country, so we are sensitive to that. Whether you're in Texas or California or Florida, or where did we have one just recently in New Jersey, right? So it's important that you understand that it's not always exactly the same, but they will be recognized. The part that gets missed is people move state to state to state, and they forget to get their properties titled into their trust. They move from Florida to New Hampshire, and they never put their new house in their trust. So if the house isn't in the trust, it's going through probate. Good question. Another one?
What is the gift allowance in California?
The gift allowance. Okay, so that's actually going to be a deeper conversation to kind of go into the specifics. As far as gifting, I won't go into topics like that because that's more tax law and tax type specifics. And we'd have to get into your specific situation during your assessment to find out, to kind of open and unpack that. but it is a good question. What are the gifting or the gifting limits? That is a question we can get into for sure, but not on this call today. That's a great question though. All right, we got a little more time. Any more questions? Oh, got a question. Oh, sorry, I just want to pop into you. Go ahead. Let's see. You said, do you recommend doing irrevocable trusts for your minor children at the same time you do yours for yours and your spouse? And is it affordable, or is it 3 separate trusts? That's a lot of stuff in a question. We have to give you a special 1-900 number for that question. The answer to irrevocable trusts, let me just simplify it by saying irrevocable trusts are exactly what they sound like. They are trusts that are actually just, you can't change them. When we talk about a living trust, we're talking about a revocable living trust, meaning that you and your spouse can change it. It's fluid. You can do things with it. As long as you're alive to do it, you can change it. An irrevocable trust, in some cases, for the kids makes sense. Now, because I've worked with lawyers for so many years, I'm going to actually answer this question just like a lawyer would. I'm not playing a lawyer on TV, I promise, but a lawyer would say this: it depends. And that's exactly what I'm going to say. It really depends. That when we get into the specifics of your estate plan, sometimes, yes, we will have specific irrevocable trusts that are built and constructed around a very specific plan for the next generation or 2 or 3. So that's a great question. And it is often multiple trusts. Sometimes we can build trusts like children's trusts within one living trust, and we'll build children's trust provisions that come to life if you die. Other times we will specifically recommend separate standalone trusts. So the answer is it depends. All right, we have time for maybe one more and then we'll wrap it up. All right, I think we have got to the end of our questions. And really appreciate everybody taking the time tonight. This is great. We will have a recording of the workshop coming out probably tomorrow, and we'll send an email out to everybody. Just remember, if you want to get in for your assessment, send me that email, because I have to, we get really busy after these workshops. So with all fairness, I will just take everybody's appointment in line. Send me an email, Kraig@barthattorneys.com. And I'm very much looking forward to talking to you. Take care, everybody.